What is the sudden urgency of seeking his disqualification at this stage? Well, the court will recognize mischief when it sees it.
You know, without necessarily interfering,
Can I finish?
Mr. Musangi is there and should be arguing
Can I
this case.
finish, please?
Yes.
Speaking for myself, my lord, I lead the Attorney General's case.
Yes.
I am not on record. I've filed no papers. Every single piece of paper filed in this matter has been filed in the name of the Attorney General of the Republic of Kenya. But look, we have no intention of arguing those applications today. Our intention is to abide by the directions of this court, given on the 16th of April, to argue the applications for conservatory orders. As I see it, my lord, there are two paths open to the petitioners. They can defer arguments on the application for conservatory orders, in which case I would suggest that the court discharge the status quo orders and then we can choose at their election what they would like to do. They can decide, because, my lord, they have filed multiple applications. Only this morning, my lords, your leadership, the respondents have been bombarded with an amended petition with a further affidavit supporting the amended petition, with submissions in support of the application for disqualification.
They give for this is to be done.
Within a defined time frame, you know? Within a defined time frame. That time was 7 days. Today is day 10.
So then stick that.
Yes.
Yes, continue.
All this, my lord, in an attempt to distract the respondents. But I'm sorry, the respondents will not be distracted. We will not be distracted. Let them make their election. But we're ready this afternoon to abide by the court's directions, to hear the application for conservatory.
Thank you. Very brief. What are you
Very briefly, Mr. Aga has just about covered it all.
Okay.
But let me
Yeah.
just add this. When a court gives directions, parties come to court prepared for a purpose. This ambush is akin to a party coming to court and suddenly saying, I want to go for the substantive hearing of a suit, when the purpose of that attendance was, say, mentioned for directions. And I'll speak for myself when I say, I have read one application by the first petitioner, and this morning, a second application filed by the second petitioner. And I didn't trouble myself to even begin drafting a response because I knew the court's directions for today were very clear. And we would have ample time to take directions on filing responses. I filed one response to the first petitioner's application. Once I received it, today I've received another one. On top of it, laden with submissions. My Lord, that's not what we came to court to do today. And it's not what we prepared for today. Today had a very clear direction. We'll hear the arguments on conservative orders, and we have 30 minutes. Let's use the 30 minutes for the purpose your Lordship is doing. That's all right.
My Lord, just a quick response to what Senior Counsel Mohanga just said, and of course Osandi. When my learned brother says the court should be able to recognize mischief when it sees one, that actually is in the province of imputing and proper. We're all senior people here. The interests at stake here cover every Kenyan, we believe. And therefore we are coming to court with clean hands, with very honorable intentions, to make sure that Kenyans get value for their money. And yeah, we will take your directions and proceed. But to begin to argue almost in a manner like what you do, you know, we will not be distracted. We are before a court of justice, and we do so in the true belief that justice will be served in this matter. And I recall clearly Council Lempaa was asked to refile. We filed the amended petition. That is also in line, so there's no question of bombarding the respondents. But having said that, Your Honor, your ladies, we are ready to take your guidance.
Your Honor, if you allow, I would say that I do not know how he has demonstrated that by us dispensing the matter on him not being here in a proper manner, affecting the conservative order. And for us, we have demonstrated that his participation in a matter that he should not participate in, is then disqualifying later, is going to affect the outcome of this discussion. So if you are not supposed to be a player, and you have played and the match is over, is when you disqualify you. I'm sure only logic can make sense of that. And I think that legal abides a lot from that. And I find it logical for him thinking that he should not even dismiss himself. I'm sure he should actually do so. Dismiss himself by saying, I find conflict here, let this thing proceed. So we cannot be able to discuss the matter when we are saying there's a conflict of interest in the matter, then disqualify a party afterwards. That's the point Your Honor I'm making here. And I think that he has to demonstrate to you whether if he is disqualified first before hearing, whether that will affect the hearing on the conservative order of the Honor. Thank you.
view that whereas the issues which you are raising of which presentation are serious matters, but looking at the nature of the assignment before us, which is a question of conservatory order to serve the subject matter and the positioning of the attorney general in these politics. We feel that it is in the best interest of justice that we hear the application for conservatory orders. And then those other issues of representation, we shall hear them immediately thereafter before we hear the petition and settle one. So that's the view we have taken, and let's proceed on that basis.
Mr. Blackmore,
We can start.
Yes.
Give you 30 minutes.
Yes, yes, my lord.
Apply yourself to the conservatory.
Yes, indeed.
Then thereafter, because there is also a list of directions with respect of all the others. All the other applications and issues, we should still be able to do it.
Good afternoon, Your Lordship,
Yes.
and my ladies. Your Lordship, I'd like to raise a small housekeeping issue.
Yes, yes.
My client is being referred to as the 8th respondent, but I act for Vodafone Group PLC. The petition has now been amended. From what I recall, the directions were to file an application for leave to amend. But the petition seems to have already been amended, and there is now an 8th respondent called Vodafone Kenya Limited. That is not who I act for, Your Lordship. So I think it's very important for us to have this right, because
So
Justice...
have you been removed from record by the amendment?
Your Lordship,
Or you have been retained?
what the problem is, Your Lordship, when Justice Mugambi consolidated these petitions,
Yes.
we took the liberty to send a heading of the consolidated petitions with 10 respondents to the petitioners as well as all my other colleagues.
Yes.
But Your Lordship, everybody has continued to file plein pleadings in the way they had instituted them. So, but there are 3 petitions consolidated, but that is not how the record reflects, unfortunately, Your Lordship. And Your Lordship, the last point, the petitioner who has sued my client, not in court, is not interested. But my client is being lumped with legal fees, having
So we should deal with that question formally. Yeah, we should deal with it formally. Once you are proceeding, then either you wait for it and or you apply to be removed.
which I have, Your Lordship.
I know you have applied
Yes.
to be removed, isn't it? So we shall deal with your application. Don't worry. When we do consolidation, my side is we do a mechanical outline. The party say now, this party is now the petitioner. That one is a petitioner. But in the absence of that, we refer to that. But we shall not tonight, don't worry.
Thank you.
So I think let's go to the substance
Thank you.
of the matter.
Thank you, my
What is
lord,
there now? So
ladies.
time, Ivan?
Yeah, we try to keep within
Yes.
the 30
Your
minutes.
30 minutes.
Thank you. We think we could give you a brief overview of where we are and the core relief sought. That the first petitioner applies for conservatory orders to maintain status quo and preserve the substratum, and an order compelling petitioners to full disclosure, evaluation reports, transaction advisors, procurement records, cabinet approval, and competition authority exemptions. And we will be seeking an order for preservation of the ownership, control, governance, and management of Safaricom PLC as at the filing date. My lord, my ladies, on December 3rd, 2025, Vodafone Kenya, the 8th respondent, announced its intention to acquire the government's 15% stake in Safaricom PLC. And on December 4th, National Treasury tabled sessional paper number 3 of 2025, proposing partial divestiture over the over 6 billion shares to raise revenue for infrastructure. And this is very peculiar, my lord, my ladies. Sessional papers prepared and tabled without any public participation, a clear breach of Article 10 of our Constitution. And on the 23rd of March this year, this Honorable Court issued an order directing that the status quo be maintained pending determination of this application. Of critical point, my lord, my ladies, for you to note is that despite the court's explicit order of 23rd March 2026, the National Assembly approved the sale to take effect on the 1st of April. A direct contravention of this court's authority. And an abuse and disregard to this court. My lord, my ladies, the government proposes to sell at 34 Kenya share against the prevailing market price of over 80 shillings per share. And during the substantive hearing of the petition, we will be able to prove this fact. The undervaluation represents a loss of approximately 250 billion Kenya shillings to the Kenyan public. 250 billion, my lord, undervaluation. The sessional paper does not specify with precision how the proceeds will be applied. My lord, my ladies, revenue sharing, revenue raising, I beg your pardon, through asset sale, this particular one as proposed, contravenes Article 209 of the Constitution, which limits revenue measures to taxes, to charges, and debts only. That this goes to the consolidated fund. That is the way this country has been doing business since we became independent. I perhaps need to mention that this matter of an infrastructure fund, sovereign fund, whatever, is also subject to litigation. But I wanted your lordship and ladies to please take note of the gravity of this contravention of our constitution, and particularly at Article 209. The legal framework, my lord, my ladies, mainly the conservative orders are a constitutional remedy under Article 23 of the Constitution, not ordinary civil injunctions. And we proffered, I think, through the submissions, 3 definitive authorities which govern their grant. The first is Gitarao Peter Munya versus Dixon Mwenda Kilinji, very often quoted, 2014 Kenya Law Reports. It's a decision of the Supreme Court. Say the conservatory orders are granted on the inherent merit of the case, bearing in mind public interest, and I want to stress public interest, my lord, my ladies, constitutional value, proportionate magnitude, and priority levels. Not merely the private party test of irreparable harm. Number 2, my lord, my ladies, Invesco Insurance Company Limited versus MW Minor 2016 Kenya Law Reports, where it was ruled that a conservatory order is an order of status quo. A judicial undertaking that no action of any kind is taken to preserve the subject until the suit is heard. The third authority, my lord, my ladies, is that of Judicial Service Commission versus the Speaker of the National Assembly, 2013 Kenya Law Reports. And our submission, my lord, is all the 3 limbs are satisfied. Number 1, public interest. Safaricom PLC is a strategic national asset holding the data of millions of Kenyans. And our submission is that handing it to a foreign entity compromises even our digital sovereignty. The sale, rushed, opaque, and non-competitive with no public participation for either the transaction or the session of paper itself. My Lord, my ladies, Supreme Court in British American Tobacco PLC versus CS Minister of Health, 2019 Kenya Law Report, held that public participation must be genuine, must be comprehensive and inclusive, none of which was observed here. And my learned brother John Ohanga, when he talks of recognizing mischief, we truly do in this matter. The second limb is that on constitutional values. Impugn the transaction 10, 73, 201, 206, 227 of this country's constitution. A document I can tell you, my lord, my ladies, I personally value. We fought for this. Kenyans have a document that keeps us together. Article 10, Article 2, enshrines the rule of law, public participation, good governance, transparency, accountability, and integrity, all of which, in our humble submission, are absent here. As mentioned earlier, Article 209 expressly limits revenue raising to taxes, charges, and debts, as well as asset disposal. Asset disposal is not an authorized mode. The process was designed to be vague, opaque, shielding fundamental issues from public scrutiny. The third limb, so that I'm within the 30 minutes, Your Honor, Your Lord and ladies, proportionate magnitude. The scale of constitutional violations involving the Kenya shillings 250 billion public loss, loss of data, sovereignty, and contempt, coupled with contempt of this court, is indeed grave and will be irreversible if this administration is allowed to continue with this transaction. The public interest in preserving the Constitution far outweighs the government's argument that it will realize 240 billion from this sale, or giving away 250 billion on the other hand. And one can only imagine what are the underhand negotiations. Even in public administration, the rule of law is paramount. Fiscal justifications cannot override constitutional imperatives. My lord, my ladies, allowing this sale to proceed will render the main petition nugatory and cause harm that cannot be undone by any future court order. And I see my friends, the respondents, in a hurry to get these things lifted so they can make their kill and leave Kenyans hanging high and dry. Allowing this law to proceed, Lord, Lordship and ladies, will cause grave economic injustice to our country. All those Safaricom users, all those M-Pesas, as we said last time, a Kenyan invention of global recognition, just gets sold off. . As to the matter of raising a prima facie case before the grant of conservatory orders, one has to, of course, highlight the possibility that you have an arguable constitutional issue or issues that are established. And the standard was set in MRAO versus First American Bank of Kenya, a 2003 Kenya law reports, and affirmed in David D. and others versus the Attorney General in 2021 Kenya law reports. A prima facie case is not one that must succeed, but one that is genuine, arguable, and discloses a right apparently infringed. I think I'll allow my friend 2 minutes to complete the rest of it, your lordships.
Yes, thank you, Senior, for that elaborate submission. My lords, my ladies, the petitioner's submission were filed on the 17th day, 29th day of January 2029. And in these submissions, my ladies, my lord, we have an elaborate overview, and we have itemized issues for determination, which are whether the application meets the threshold for grant of conservatory orders, which my learned senior counsel, Honorable Kalonzo Musyoka, has demonstrated, whether the application raises prima facie case. Indeed, he has done that, and whether the application is merited. I do not want to rehearse what he has said. He has actually mentioned all the cases in summary that are found in these submissions. But over and above, my lord, my ladies, it is very clear that this matter involved 2 levels of public participation. Level number 1 at the policy level, where the Treasury came up with sessional paper number 3 of 2025. Whether that was taken through public participation, we do not know. Secondly, the second level of public participation is at Article 118 of the Constitution of Kenya, where Parliament was supposed to be involved and taking Kenyans through public participation as their representative. My ladies, my lord, if you look at page 31 of the Hansard that is attached to the replying affidavit to that of John Ng'ong'o Badi, you would find the Hansard where Mr. Honorable Karoli Omondi, the MP for Suba South, trying to bring it to the attention of the Speaker of the National Assembly that there exists a matter. And he quotes it clearly, HCC HR petition A051 of 2026. And actually invokes the right standing order by telling the Speaker that the committee of the 3 arms of the government does not allow any one of the arms of the government to deal with the matter that is in the hands of another or is first in the knowledge of the other arm of the government. That is clear demonstration that public participation was even denied to members of Parliament. My lord, if you look at the LSK memorandum that LSK presented in a bid to try and be heard in public participation, which was ignored, the memorandum is marked as TG6 in the affidavit. And my ladies, if you look at what that particular memorandum says on page 8, the use of proceeds after the sale glowingly about is not even disclosed. They talk about an amorphous sovereign, I don't know. And they say, we propose a comprehensive fiscal impact assessment before any reduction of its shareholding, quantifying the long-term loss of dividends. Sorry I read the wrong, whatever. The use of proceeds. It starts from page 8. They say the sessional paper fails to provide clarity on how the proceeds will be applied, including whether the funds will be ring-fenced for development expenditure, and if so, under which regulatory framework, debt reduction, or will otherwise be utilized for recurrent spending. That's what LSK says. But all this is ignored. And in the conclusion, LSK actually is lamenting that the government of Kenya must handle the transaction above board, considering and mitigating all the legal, social, and economic factors and risk arising in the sale of such a critical asset to foreign entity as a precedent. The LSK agrees with the government of Kenya on the need to debt-free infrastructure.
Yes, order it. Therefore, my lord, my ladies, orders we seek are: one, a conservatory order restraining all respondents from selling, transferring, alienating, charging, or executing any agreement concerning the government's 15% stake in Safaricom PLC. Secondly, a conservatory order restraining any further steps to implement or complete the transfer to Vodacom Group or any other entity pending full hearing of this petition. And thirdly, Your Honor, my ladies, an order compelling the first, the second, and sixth respondents to file and disclose full valuation, names and appointment letters and procurement process of all transaction advisors, and as I said earlier on, cabinet approvals evening, as well as competition authority approvals, and all other agreements, MOUs, term sheets, and binding offers exchanged with Vodacom Group, and we also ask for cost of this application. My lords, action goes through at whatever cost. That's why my learned brother was able to say, we will move on, whether you like it or not. That's why we are here. Let's conserve what we have for the future generations. And when the time comes, everybody will, as a country cannot be proud of. That having said, your Lord, my final conclusion, the famous NADICO reports, we had it all. We had it all. This country is hurting. It is hurting, and if you now leave to the status quo, allow my friends to make their billions and run, what are we doing to our future generations? We thank you.
1 minute. Yes, Your Lordship. Your Lordship, permit me to refer you to the replying affidavit. Only 2 minutes.
Who's keeping tape?
I was keeping time.
We are lucky no one was.
Around their time.
Just 1 minute, please.
Well, he has lost it.
Oh, they have 25 minutes. They have 5 minutes.
Oh, you are fine.
Your Honor, the second petition.
Yeah.
You will also be given.
You will not waste time. Well, I will put you.
So, Your Lordship,
I'll give you. So just 1 minute.
I will be less than, because I want to draw your attention to the affidavit filed by Wangeshi Gachoka, who is the 6th respondent, head of legal service. She says she's competent to swear this affidavit, and you refer to paragraph 14 and paragraph 15 of the said affidavit. That paragraph, Your Lordship, it will indicate to you and prove to you that a prima facie case has been laid out. It's dated with it's not dated. Just that it's not dated, but it's on record. Yes, Your Lordship.
When was it sworn?
It's not dated when it was sworn.
How is it when it was sworn? Is it commissioned by commission of our?
Yes, it's commissioned.
Okay.
Well, we don't have a date in what we were served.
Who is the deponent?
The deponent is Wangeshi Gachoka.
February 2026.
It's all right. So, Your Lordship, my point was that those two paragraphs, 14 and 15, actually 15 indicates that each of these information institutions have publicly and formally affirmed which institution, the oversight by the Capital Market Authority, the compliance with the Nairobi Stock Exchange listing rules, and the Competition Authority. So we are at the final stages with Mr. Lempaa having confirmed that Parliament has carried out a mockery of a public participation. So if we do not get conservatory orders, Your Lordship, we may not have a petition before you to urge. That is to Your Lordship, that in the interest of the public, it would be, and with the confirmation of the 6 respondents, the balance tilts in our favor. Even if you were to apply the doctrine of proportionality, it again favors the petitioner. That in the interest and in the balanced proportionality, Your Lordship, and the interest of preserving the. This is my final point. And in the interest of preserving even the amended petition, again, Your Lordship, the balance tilts in the favor of the petitioners, granted that the state suffers no prejudice by granting these prayers sought. It is the petitioner and the people of Kenya who stands to suffer greatest loss and prejudice. I rest my case.
Please don't repeat what I did. Just add.
Yeah, thank you very much, Your Honor. Ladies, I will make my petition without submissions, without repeating what the other council have said, and I'll be very structured. The first one will be on the nature and the scope of this consultative order. The second will be on the application principles governing the grant of this order. And lastly, whether the applicant has satisfied the threshold to be given such orders. So I start with the nature of these conservative orders. Your Honor, the jurisprudence on conservative orders are very clear, especially in the Constitution of Kenya 2010. And court have consistently affirmed that the conservative orders are distinct constitutional revenues designed to preserve the status quo, which are in public interest. And unlike the interlocutory injunctions, conservative orders are not primarily concerned because some people think they are about the private rights.
Just repeating what council have already argued. There's something new he's adding to the conversation.
Yeah, so what I'm trying to say here is that we should not talk about probability of success.
Repeat, because that has been extensively submitted.
Yeah, there's a point I'm adding here that we should just focus on what is pending for determination today rather than whether it will succeed or not. The other point I'm putting across is that according to this corner of the code,
Yes, yes.
We do not intend to stop you, but we observe that you are reading your submissions. If they are on record, you can ask us to adopt them verbatim, and we can reproduce them in the room.
yeah, this is a highlight.
So the highlight is not reading,
Yeah.
Please, you can even highlight without reading.
Yes, so let me highlight that. Thank you.
Thank you.
So according to this, what I'm trying to say that this assessment that you are going to, that this case is seeking for this Safaricom condition, you should just focus on the merits and the substantiveness of this petition. So that about the first part. The second part is the principle to grant the conservatory orders. So I was citing the court in Gatirau Peter Munya, where it is very clear that you should were granted the license were being granted just because of the fact that you are considering the probability that in case the case finds out that the petitioner's case was having substance and you don't get these orders, it might actually make them suffer because then they will have just taken through a process that has been predetermined. So then the last one on this matter, I'm just citing the case between the Board of Management of Okuru Secondary School versus City Council Director of Education, which also agrees that there is a need to safeguard these values and prevent the frustration of this petition. The last part of that, I'm highlighting that, which is whether a prima facie case has been established, which senior councils have tried to deliberate on. This petition tries to argue that in case this is not granted, we look at Article 10 of the Constitution, which holds values, the issue of transparency, accountability. You have seen even public participation being highlighted that the respondents have not conducted themselves with absolute transparency. And because of that, there must be something that we might actually have to be given a chance to explore before you go. The other one I want to state that in any case, there's been a lot of things being discussed here that some of them don't make sense to me. Your Honor, my ladies, you know that one of the council we had last time that the government will be losing money if they are not allowed to go on to the sale because of the money they want to make. And Your Honor, all of us here, there's a lot of learned people here, and they know that the law can be deontological, the law can be based on utility, and the law can also be based on virtues. Deontology is do the right thing, period. When it's wrong, no matter how many consequences. And I had my senior Musangi arguing as a consequentialist by arguing that the consequences are very high if you don't get the prayers. According to me, whether only one person will be happy, but do the right thing, we should just do it. And arguing the government is losing money daily, so we should allow them to continue. He's actually not arguing as per. We should argue if you look, the law is more deontological, not that rejects the utility, but more deontological. Because if all of us are in this room, and we can use the law by saying, we use democracy, and we said we can vote if somebody must smoke here, but there must be somebody with asthma, could be only one person. So many of us can say, let's move because majority is here, but you find that what will become of us if one person suffers from asthma just because of our negligence? So no matter how many, because the argument here that Kenyans are very many, all of them should come here, Mama Mboga. No. Even if only one Mama Mboga will be affected, it will affect the in conclusion, Your Honor.
Please.
Sorry? To make conclusion on my submission, just to finish, if I say, that the question number 2, Fred, I is satisfied that the threshold has been met to give the orders. We have raised interest, and I don't think there's any case which will demonstrate public interest on this one because it touches every household. M-Pesa is in every room. I think it's in my bedroom, it's in my sitting room, it's in the corridor, it's in my TV. I think it's just everywhere. And we don't want to play with it, apart from the fact that senior counsel Kalonzo Musyoka who talked about elections. Safaricom uses a lot of intelligence in our lives. I'm sure you had even arguments here where they say there's volunteer information for some of us to be abducted and to be arrested. And you can share. And I want to say that there is what we call sovereignty of data. Data already board carries every information. Some have even told me, one of the members of parliament told me that he went through a technology system in parliament and they could demonstrate that even if you want to use Safaricom to know those who have concubines, they can tell you. So this information becomes very critical. That cannot be shared across the board. Your Honor, and I end there. Thank you. Thank you. I've used my time much better than they did. Your Honor.
Thank you very much. Now respondents.
Yes,
So you have 30 minutes.
yes, we
Tell your submissions in a way that you keep within the document, and we are not going to proceed with that.
my lord, we will be very,
You know what that means.
we'll be very efficient. I will take 20 minutes, Mr. Musani will take 10 minutes.
No. Your time starts now.
Thank you very much. My lord, let me, in order to save the court's time, can I ask that my arguments on the 16th of April be adopted? As setting out the foundation or framework of the respondents' arguments in opposition to the application for conservatory orders. The first, second, fourth, and fifth respondents have filed 2 affidavits, both by the Cabinet Secretary for the National Treasury. The first was sworn on the 26th of March, 2026. And the second was sworn on the 8th of April, 2026. They set out very comprehensively the factual position relating to the government's decision to divest 15% of its shareholding in Safaricom PLC. The first, second, fourth, and fifth respondents have also filed 2 sets of written submissions. The first set, my lords, was filed and is dated the 12th of February 2026. And a supplementary set of written submissions was filed with the leave of the court on 17th April 2026. The affidavits, as well as the submissions, read together in their totality, provide a comprehensive answer to the case made out by the petitioners. My lord, your ladyship, turning to the application itself, which contains 8 prayers, in my respectful submission, only prayer 3 and perhaps prayer 7 relating to costs and 8 remain alive. Prayer 3 seeks that pending the hearing and determination of a petition, a conservative order be issued restraining the respondents from proceeding with the intended sale, and so on and so forth. Prayer 4, my lord, your ladyship, seeks disclosure of certain information I am uncertain why this disclosure is required, because the petitioners have themselves asserted in full matters relating to the value of the shareholding, their allegations as to the impropriety of the choice of transaction advisors, and so on and so forth. And in my respectful view, that prayer is now moot. The fifth prayer is overtaken by events because it sought that an order be issued declaring that no disposal of government of Kenya shares shall proceed without prior parliamentary approval. As the court is now aware, that parliamentary approval has now been granted on the 31st of March 2026 under the provisions of Section 87A of the Public Finance Management Act. Let me turn now, my lord, your ladyship, to the substance of our arguments very briefly. I do not wish to trouble you with the authorities relating to others. You are well aware. In our respectful submission, they have not been met. That is all that I wish to state. The sale of shares in government-linked corporations is governed by Section 87A of the Public Finance Management Act. That provision has not been impeached, and there is no attempt in this petition to impeach that provision. Absent a challenge to that provision, the petitioners cannot restrain that which the government is allowed to do under statute. There have been arguments made about public participation, about the views of various parties, the Law Society of Kenya, and so on and so forth. Note the affidavit of the Cabinet Secretary sworn on the 8th of April 2026 goes to great lengths to detail the nature of public participation, the various groups that were consulted, and the output from that public participation. The Supreme Court has told us in British American Tobacco that the fact that you do not agree with the eventual views taken by the policymaker does not of itself suggest that there was no public participation. The only thing that the petitioners are saying is that they do not agree. They do not agree with the pricing, they do not agree with the methodology, they do not agree that the shareholding should be disposed of. That, my lord, is not sufficient to displace the fact that Parliament has said it undertook public participation, and this was the output from that public participation. If it is intended to impeach the manner in which Parliament undertook public participation, then Parliament should have been joined to this petition. And so the failure to join Parliament is fatal to that argument. It is alleged, my Lord, Your Ladyship, that the approval by Parliament was made in breach of the status quo order. Nothing can be further from the truth. First and foremost, as I've said, and I will repeat, Parliament was not a party, is not a party to these proceedings, and cannot be bound by the orders that were made on the 23rd of March. We have dealt with this very clearly at paragraph 53 through to 60 of our supplementary written submissions. But what is more, Your Ladyship, is that when the judge, the learned Mr. Justice Mugambi, made his order on the 23rd of March, 2026, he was well aware that the matter was before Parliament. In the ruling itself, the judge states unequivocally that the matter is now before Parliament, and Parliament has now dealt with the matter and granted its approval, which will take effect on 1st April 2026 or later. Those appear from the decision of the learned judge himself. If the judge intended, therefore, this situation, if I can just step back so that if my Lord, Your Ladyships have any doubt, that is at paragraph 36 of the ruling of Mr. Justice Mugambi, dated 23rd March 2026. If the learned judge intended that Parliament should be restrained in the full knowledge that the matter was before Parliament, he would have said so expressly. Well, I want to conclude by pointing Your Lordships to comparative jurisprudence. Comparative jurisprudence is a great assistance in shining a light on the jurisprudence of our courts. We have provided the court with the decision of the Supreme Court of India in the case of Balco Employees Union versus Union of India. Taken 13.
Yeah?
1-3.
16 minutes.
Safaricom employees, this is video, and we have set out there. I will not trouble you by reading the full extract, but essentially, the Supreme Court of India was of the view that this investment is an economic policy decision, not to be second guessed on the merits, absent illegality, malafide, or constitutional or statutory breach. The process of this investment involves complex economic factors, which, my lord, the leaderships should be left to the policy makers. The Cabinet Secretary has gone to great lengths to explain himself and to explain the rationale for his policy position. Similarly, my lord, the Constitutional Court of South Africa, the National Treasury versus Opposition to Urban Tolling Alliance, was of the same view that courts should not grant restraining orders against the exercise of statutory power except in exceptional cases and only when a strong case for that relief has been made out. Courts must refrain from entering the exclusive terrain of the executive and the legislative branches of government unless the intrusion is mandated by the Constitution itself. Lastly, my lord, we have put before the court two decisions of Mr. Justice Mamuye, sitting as a single judge, in relation to the challenges to the privatization of Kenya Pipeline. This is on the principles which we have placed before this court. Declined to grant conservatory orders, restraining the government from disposing of its entire interest in Kenya Pipeline Limited. And eventually declined to uphold the petition itself. Both decisions, my lord, are in our list and digest of authorities which are available to you. In the result, my lord, the leadership, it is our respectful submission that the totality of the facts as well as the law are against the petitioners. I have had repeated references to Mama Mboga. I have not had one petitioner suggest how this affects him personally. In our respectful submission, we ask that you decline to grant the conservative order sought. There are sufficient safeguards in place as the cabinet approval as well as the parliamentary approval demonstrates. There are various gates: Competition Authority, Communications Authority, Nairobi Stock Exchange, all of which must be satisfied before this sale can be consummated. The sale, my lord, your leadership, is proceeding lawfully in accordance with the statutory architecture, and there is no reason to conflict.
certain bullets spring to mind when I listen to submissions, but let me start where my then just left off. The process is going through the motions. The motions are prescribed by law. You've had a submission, judges, that it's being rushed. But the same people who tell you it's being rushed acknowledge that it was announced way back in November 2025. If there was a rush, why are we still here? You have then listened to the same petitioners acknowledge that Parliament, who got seized of this matter in January, took until the end of March to consider the views of the public before reaching an outcome. You have been told that even that outcome from Parliament is not the final stroke. There are still regulatory approvals that must be on the table, and even Parliament themselves recognize that and said subject to all other regulatory approvals. So, my lords, the submission that this has been a cloak and dagger affair couched in secrecy is not honest and is not factual. Due process is being followed. We are talking about an ongoing process. So, my lords, in that context, the conservatory orders being sought are actually being sought to hamstring an ongoing statutory process. And this lends credence to the submission that where there are specialized institutions with constitutional or statutory duties to analyze and consider and approve or disapprove of a transaction, they should be allowed to do their job without interference. Honorable judges, there's certain rhetorical sound bites that have been thrown at the court, but they are without factual basis. I've had His Excellency Senior Counsel submit that the market price is 80 shillings. I think you only need to Google that for yourselves, and you'll find out that that submission is not accurate. The court has been told that revenue raising should be limited to taxation and levies and cannot happen by way of disposal of shares. Again, let me remind the court about facts. Safaricom had an IPO in 2008. We have all been told about it by Madam here. That IPO raised funds for government. And lo and behold, who was in government at the time? His Excellency, the Vice President, who sat here and said you
Your
cannot
Honor,
raise funds.
I object to such type of submission. If it is not in an affidavit, he's giving evidence from the bar, and he has waited for learned counsel to go out for him to throw epithets at him. Your Honor,
May I respond?
my lord, when the learned senior started, he said that he's under the weather.
No, not during your reply.
Yes.
You responded to
And Mr. Musangi has this habit of submitting from the bar because the chairman of Central Bank.
No, he let him submit on something which is not.
Yeah, he should not attack parties who are not.
My lord,
Avoid factual.
first of all, may I respond?
No, I'm saying you submit on it.
Absolutely.
Avoid factual.
Absolutely.
Proceed.
Which are not in an affidavit.
Yes.
The IPO is in their affidavit.
Is Mr. Kalonzo
They have
Musyoka
stated.
in that affidavit that he was in government then?
Okay.
And if he wants to invoke section 60
Mr.
of the
Lempaa has
evidence
raised his objection. He's eating into my time.
Take a seat.
Can we stop the
Submit. If you go beyond, I will stop.
Absolutely.
Yes.
My lord, there's also something called judicial notice. We are all Kenyans. We know who was in government in 2008. Let's not make it an argument. But what is important is not who was in government. It's the fact that government raised funds through an IPO. I think that point is settled.
That is what we have recorded.
Perfect.
The other thing
In fact,
was
that's-
in the government, forget about it.
Absolutely.
It's not
Absolutely.
Yes.
What is critical for us to note as we move on is that is also not the only IPO. My lords, they raised paragraph 14 and 15 of my client's recline affidavit. Paragraph 14 simply reads and confirms the proposed divestiture process is expressly subject to oversight by the Capital Markets Authority, including approval, disclosures, pricing methodology, investor protection safeguards, and market conduct compliance. Compliance with Nairobi Securities Exchange listing rules, review under the Competition Act. That paragraph confirms that due process is subject to all these checks and balances. It is not a process going on in a vacuum. It is ongoing within a very controlled environment, both governed by the Constitution and statute. My lords, you are also told that our data is under threat. The Data Protection Act has not been repealed. Safaricom PLC is a Kenyan entity that is subject to the laws of this country, including that Data Protection Act. And this is regardless of who its shareholders are. And even if a company ends up being 100% foreign owned, it is still subject to the Data Protection Act. My lords, the last time I stood before you, I made submissions on the balance of convenience and the impact of not allowing the divestiture to go through its logical process to conclusion. And I pointed out that there is an impact from non-remittance of the sale proceeds on government. And I was told I'm submitting from a position of personal knowledge. What I have done is I have now attached supplementary submission, which the court gave me leave to file, to show the provisions of one, the Public Finance Management Act, require any funds in the possession of a government entity or the government itself to be invested. Number two, and this is prior to use, even under the National Infrastructure Fund Act, where these funds are slated to be deployed, the Act itself has very specific provisions demanding that prior to deployment, idle funds shall be invested. Shall be invested. It is not a matter of choice. So every day we sit here, we should not be told that these conservatory orders have no impact on the public. And I'll just reiterate one submission before I sit, because I think I'm still within time. I want to give Mr. Muganda 2 minutes, the remaining 2 minutes. The impact of non-remittance of these funds cannot be denied. These are not neutral conservatory orders. These are conservatory orders that are denying the people of Kenya resources. My lords, I would urge that the court balances the position of the two parties. And finally, when you consider this, please recall, honorable judges, if they prove illegality at any point after hearing the main petition, and you conclude that this transaction is illegal, Article 23 and your inherent powers per se allow you broad remedial powers. You can reverse it if they prove their case. But please do not award them the case prior to them proving that there is actually any illegality at all. I rest my note.
Uganda, my lord. Uganda. Yes, my lord, for the third respondent.
Uganda, how many minutes are remaining?
1 minute.
Yeah?
My lord, we rely on our submissions, which you filed, my lord, on the 19th of March 2026. Well, the first point to note is what Mohammed has indicated, is that not a single statutory breach or not a single constitutional infraction has been pointed to you by any of the bodies that are licensed or mandated to review and approve the sale of the Safaricom shares. Not one, my lord. That's point number one. Number two, my lord, it's important to appreciate the PFM Act, my lord, and I'd invite my learned judges to consider number one, the preamble to the PFM Act, an act of parliament for the effective management of public finances by the national and county governments, the oversight responsibility of parliament and county assemblies, the different responsibilities of government entities and other bodies and connected purposes. My lord, that is the preamble to the PFM Act. My lord, let's move to section 87. My lord, section 87 is called in mandatory terms, and it says, the national government may sell or dispose of all its shares in a government-linked corporation with approval of cabinet, which approval of the cabinet may only be given taking into account any recommendation of the National Treasury regarding the financial implications of such shares. The sale of shares in a government-linked corporation shall only be done with the approval by resolution of the National Assembly. My lord, what you're being asked currently is to stop a constitutionally mandated process, a statutorily mandated process. My lord, what is the effect of Parliament in this? My lord, I'll invite you to consider Article 1, which gives power and authority. Article 1.2, the people may exercise the sovereign power either directly or through the...
Your time is up. I'll give you 1 minute.
Very well,
Start
my lord.
reading those articles. We are aware of them.
My lord, I'll read to
1
them.
minute only.
Very well, my lord. So that the investor is through Parliament. Parliament, my lord, acts under the powers given under Article 1. My lord, I had referred you, and I hope you rely on my submissions previously reiterated. Article 93, Article 97, my lord. My learned indicated that an approval has already been issued.
Please do not interfere. Intervene.
My lord, in this instance,
Yeah, you are assuming that we are in the business of interfering.
I will retort and say intervene, my lord. My lord, an approval has already been issued. In the approval process, you have not been told one infraction conducted or performed by Parliament, which, my lord, is important to note that the petitioners intentionally chose not to join them as parties to the suit.
Are you through?
My lord,
Finish the 1 minute I gave you.
yes,
Yeah,
I
my
will.
judges here, I not agree to it. I just used my fear.
My lord, lastly, my lord, you have been referred to Article 209, and my lord, it is on taxes. It has nothing to do with the process which is before you. That is by my landed senior Kalonzo Musyoka. And as I sit down, my lord, it's important to note that you have been referred to wrong sections of the law. You have been referred to the Public Procurement and Asset Disposal Act. You have been referred, my lord, to Public Privatization Act of 2005. The government statute is the Public Finance Management Act. As I rest to that, my lord, I ask that you dismiss the petition.
Now, 5 minutes only. 5 minutes.
5 minutes.
You know,
My lord,
you think.
5 minutes. He takes his 5 minutes.
Yeah?
He takes his 5 minutes. We are comfortable with 5 minutes.
For both of them.
Yes, it's to both of you.
Take 2.5, give it to her.
My lord, without much ado,
2.5, 2.5.
no problem.
Yes.
My lord, it is amazing and intriguing how the respondents want to limit these particular proceedings into a statute when it has raised serious constitutional issues. 201, 209, they are trying to raise revenue through Part 3 of the Constitution, which is not even allowed. My lord, you have been told by my learned colleague, senior Mr. Ohaga, that Parliament has already, that most of the orders that are being sought have been overtaken by events. A party cannot come here and tell you that we have violated this. We have demonstrated that Karoli Omondi, the MP for Suba North, alerted the Speaker of the National Assembly that this matter is pending. And standing orders number 89 is very clear that Parliament must not touch on an issue that is pending before this particular court for the committee of the three arms of the government. My lord, casual approval by Parliament restricting as to article to parliamentary PMFA, Public Finance Management Act. The Lord, you have been strenuously told that in 2009 that Safaricom raised money, the government raised money through an IPO. The Constitution of Kenya had not come into place then. Article 209 was not in place then, as to restrict them on how to raise revenue and not through an not through a statute, not through a sessional paper. My Lord, you have been told that none of the petitioners here have proved personal injury, my Lord. The petitioners, very learned counsel. In fact, I applied for pupillage in triples or whatever. Is now taking us to Pre-Wangari Maathai era of saying that they have not demonstrated any personal injury. Mama Mboga, I tried as much as possible to avoid that term, Mama Mboga. But for today, I've been forced. The petitioner here is a veteran journalist who understands exactly what the sale of that particular shares. The Lord, you have been told that there is nothing that will affect Safaricom and Pesa. Your Honor, my lords, we do not want to cede our sovereign control of Safaricom to foreigners. If, for example, something were to happen and they want to cripple the Kenyan government, they would interfere. My Lord, you have been told that you have Article 23, that if you are to find that this, if you allow them to Article 23 on remedies, Your Honor, my lords, it will be very, very hard for you to reverse the sale of 15%, which is raising, is it 2.1? They are talking about a lot of millions. It would be very hard for the government to undo, or this court to undo the sale of Safaricom. So instead of actually getting there, my Lord, we urge you to grant our humble submission. Yes. My Lord, I donate 1 second to my colleagues.
Yes. Who? Mr. Nzaku? 1 minute. 1 minute. Yes. 1 minute. Yes. My Lord, my lords, and my ladies, Mr. Nzaku. Yes. Safaricom holds data, not only not only M-Pesa, of all of us who are subscribed to it. And there has not been any mention by the respondents how that data will be dealt with without the consent of the subscribers. My Lord and my Lady, the second issue that I have to raise is that public participation, as we told it, was conducted. The only thing that has been brought before this court is there's particular venues where that public participation was to take place. The details of how it took place have not been availed, who were liable, whether indeed the persons who matter were those whose data was collected. That's all. As I urge this court to allow the application as prayed.
Your Honor, thank you very much. In response to the 12.5, I'll use exactly 12.5. In response to my senior counsel by saying that the government has used an IPO before, I want to remind you that this is not an IPO. This is, that's why I call it under false analogies. And false analogies are intellectual crimes. Second thing is, they have talked about public participation. I was at the hotel during public participation submitting that they should not sell Safaricom before Parliament. And I have not seen how they factor in. We have so many organizations there. And again, I was at
No, you did tell us not to stray financial issues.
Yes.
That's exactly what is happening. With due respect to the good
Yes,
professor,
two wrongs do not make a
told
right.
us about affidavits.
Two wrongs do not make a right, Mr. Mukite.
Yeah, so they said public participation was done. I was part of it. I didn't see any substantive incorporation of the views we made. And I believe that public participation should not be done for cosmetic reasons. They should actually have sense. The second thing, Your Honor, you know the intention behind the sale of Safaricom is to create an infrastructure bond. And I raised that there were other alternatives already available, and there's no need, so they should not look as if the only way is to sell Safaricom, because Your Honor, you know that you can use one, PPPs is available, you can use infrastructure bonds, you can use sovereign wealth fund infrastructure, which has been proposed in Kenya, you can use DFIs to do that, you can even use asset recycling. I find that when you have really existing option to achieve the same goal, when you create another, there's a problem. I went one day to another organization, I don't want to mention the name. They had 16 bank accounts for paying school fees, meaning that when you're creating several ways to raise money, there should be something wrong when you have existing ways, because these ways have built infrastructure in Kenya. And last but not least, an infrastructure bond. You are looking at raising an amount of money when the debt hole is so huge that when you raise this money, and you know that the structure of the consolidated fund, that there's something called fast charge. And it's very clear where money should go first. According to the fast charge, money should go to pay debt first. So this money will not go there if at all the law is followed. So it's an exercise in futility to raise money when the structure raising that money will not give you what you want, which means that, as I said, there must be something very fictitious, and this government has lacked trust. They should fight to get this trust first, and even reduce the corruption we have in government, because Auditor General reports are very clear. There are other ways to fund this by just stopping the leakage that takes place in the government, and you don't have to sell your strategic asset when you can simply have good manners. And the good manners here, you can see, Senior Counsel has said here, you could see even how they argue. I wonder whether they're actually trying to understand that the government of Kenya cannot be trusted to say, you cannot, as a young boy, I was being sent to sell things. You can't send someone you don't trust to go and sell something where they're collecting money. Thank you very much, Your Honor. I always keep my time. I've moved that close. Thank you very much, Your Honor.
the ruling is going to be on 18th of May 2026 at 2 p.m. Meanwhile, the status quo ordered on 23rd of March 2026 and extended on 16th of April 2026 is hereby extended to 18th of May 2026, and we clarify the status quo to mean the status obtaining as at 23rd of March 2026. So those are the orders of the court. So in respect of that application,
Look, can I
those
just
are the
clarify
orders of
that
the court.
the
Now we
ruling
go-
will be in open court?
Yeah?
The ruling will be in open court?
We can do it, Judge? We can do virtual, is it? Can do virtual, so that,
Virtual.
let's do it virtual. We shall provide the link, eh?
We're quite fine with that.
Yes. So I think now, let's go to directions on the pending applications. And we make it very simple, because there are some applications which, if we are pragmatic enough, we should not fight on. We agree and we move forward. Because the main thing here is to do the petition. It is the only which is keeping us here, isn't it?
That's right.
Not to these other things. Because when you bring things here and then you take too much time on them, then you know that will impact on the whole intention of the expedition and your expectations. So let's move with that spirit. I would encourage you, we go that way. Like now the one for amendment. Unless there is something very serious about it, it's a matter which we can agree and we move on. Because without agreeing on the amendment application, we cannot send the petition for hearing. John, you agree with me, isn't it?
Yes, certainly.
Yeah, so there are certain things we may do now, but they will prevent us from achieving our major goal.
We have to be prudent, we agree.
Correct. That's what I suggest. Now we can start with the one for amendment,
My lord, we
despite it being served late.
Yeah, my lord, by this we have filed amended petition. It is in the CPS.
This is the CTS.
Yes. and
Now,
sir-
have you served everybody, all the parties have been served, I'll be late.
Yes.
Otherwise, you know it was late.
Yes.
Have you been served with everything on that application? I think everybody has been served, isn't it?
My lord, it's not an application. He has already amended the plaint.
Not
The petition, sorry. So my lord, it is not an application. He has filed an amended petition.
Yes, my lord,
You did file an application together with the amended plea.
No, no,
The
if,
petition.
if I remember correctly,
Yes.
we canvassed that issue and we are allowed to file an amended petition, but to file those other applications.
No, we did not. We said you apply, and I told you, you can use the same application to get leave to amend and also to join the other party. I told you that. But we didn't grant you leave. That was, you were under the wrong impression. Although that could happen,
Yes, my
we
lord,
can still discuss and see the way forward.
we intend to file an application for amendment already, although we have already done it.
Let us hear what they say. No, John was very clear. We become proactive and pragmatic,
Yes.
isn't it? Because an amendment can be done
But
on the
that-
time.
that
So
then
we
leaves-
can still agree.
But Lord, that leaves me with about four applications. We
So-
do not intend to abandon the application for the recusal of the two chairmen.
No
The chairman
problem.
of Safaricom.
We are not yet there.
Yes.
Lempaa, we are not yet there.
Yes.
We are still on your amendment
Yes.
question. So, is there anybody objecting to that pleading, the way it has
Yes, my
been
lord,
filed?
I'll
Although
be
there is that
objecting.
lapse, but let's hear, yes?
Yes, my lord, last time, when you asked me twice, actually, my lord,
Yes.
about whether there would be a problem amending the petition to
Yes.
add Vodafone Kenya Limited
Yes.
as an eighth respondent. I raised the issue mentioned by Mr. Ismail about the fact that there are actually 10 respondents in the consolidated petitions. So we should be clear about if somebody is being added, are they being added as the 11th? But aside from that, essentially the amendment to add Vodafone Kenya Limited is a concession to our strikeout application. And I urge you to have the two applications because they are interlinked.
So
Argue together.
Let's go it this way.
Yeah.
We deal with the amendment first. Once we agree that the amendment is carried through, then we ask ourselves the next question: what is the impact on other parties or pleadings which have been filed? Then that is the point at which we will come to your issue.
But my lord, my issue
But
was
do
filed
not say
in
we do
February.
them together.
My lord, my issue was filed in February, and what you are allowing Mr. Lempaa to do repeatedly is to come late to the party, file something on CTS, serve us late, and jump the queue. I don't think that is treating us fairly as respondents. I've been very quiet, my lord, the whole of today, as you have listened to all these men on this side and that side.
So what do you
This
think
is
is
my
most
chance to
What
speak
is-
to you
what
about
do
my
you think is
strikeout.
What do you think is very is
Yeah.
most pragmatic? What do you think is most pragmatic?
The most pragmatic thing
Yes.
is if you are going to allow the amendment, it means my strikeout application is successful.
Not necessarily. So
Yes,
that's what
but-
I'm telling you. We still have to determine it.
But I want to explain to you why.
Yeah.
My strikeout application, it's very brief, my lord. It's based on the fact that the correct purchaser of those shares, as has been publicly disclosed and is even conceded in the amended petition, is a Kenyan entity called Vodafone Kenya Limited.
Yes.
It is not my client, which is called Vodacom Group, which is based in South Africa. So it's not complicated. If they are amending the petition as they have proposed to say the correct purchaser is this entity, it's Kenyan, and whatever it is they want to say about people being misled, then they are conceding that obviously my client is not the purchaser.
So can you take your seat and tell you something?
Okay.
You will be wonderfully placed and positioned to argue that way if we have already allowed the amendment. That's what I'm telling you. Very simple. After the amendment, I come to you straight. You're getting it?
Okay, my lord,
Yeah.
the reason I was hesitant.
Because doing it simultaneous is not
Yeah.
even humanly possible.
No,
You can't
no.
do it simultaneously. We are not a computer where you can do it
Yes,
simultaneously.
it's
That's
just
what I'm
that,
telling you.
my lord, you understand the difficulty I have where I filed something in February. Directions were issued by the court. They were not complied with. No one within those timelines objected. And now I am being told that basically everybody else has jumped the queue ahead of me. And I'm explaining to you that this is difficult to explain to a client.
Maybe, no, there is nothing difficult here. Just follow what we are giving here. We are telling you, these are the directions of the court. Abide by them. Please, abide by them and you will find it very useful to your argument. So let's first finish with the amendment one. Immediately after that, we come to yours because that's the order, which makes sense, isn't it? So, anybody with an objection to that amendment? So that we can now come to Isha's question after we are through with that.
Go to my past.
Yes. So we say by consent, including Isha, it is for your benefit. You will come to like it later, Isha. I can see your mind. It will come to your aid, you will see what I'm saying. You can now say what is so, do we agree by consent?
My lord, the only slight hesitation, I'm sorry, my lord, I've taken the court's guidance.
Yes.
But my lord, as my learned colleague Aisha has submitted, these are inextricably linked. My lord, if everybody says we have no objection to Mr. Lempaa amending his petition and it is now accepted as an amended petition, and then when you now come to us and they say, no, we are opposing that application and it must be heard. So my lord, at that point in time, we now have a problem. Because on one hand, he's admitting by amending the petition that the right party is Vodafone Kenya Limited, but then when it comes to removing the defendants that, or the respondents that are wrongly cited, you then say, no, no, now we will have to argue that point. And that is why we are saying, my lord, they have to be inextricably linked.
2 minutes, I think 2 minutes, and we shall document this.
Very well,
Not to worry you, okay?
Very well, my
I will
lord.
not worry you.
Very well.
Yeah. So I think they leave us to do our work. That's our work. I'll give you 2 minutes if you object, but I will decide together with my colleagues, okay? So now you see what I'm talking about, eh? Yeah, nobody will suffer. So we want to remove it out of the way so that we open up the path for these other things, including that of Isha and yours, okay? So we record by consent now. You are now satisfied. We shall record by consent. And then we come to your issues, then we continue like that. Eh? Okay. So where is that? Do we have a hard copy of the proposed amendment?
Yes.
Because we, although I know if you had any problem, John would be the first one to pick up. Let's satisfy ourselves. It's our duty. Yeah? Okay, it's our duty. We'll still look at it. So we don't find any now come to you and Bishop. The issue raised by both of you is the right issue for the candidate. And it is not going to be affected by this amendment. But you may draw upon the amendment now to address your point. So it is not closed. So once we accept this, then we now come back. years. Right? So let me record that consent now. No? We wish to reply to it so that we make part of the submission here. The current reading is
14 days?
you read how many days?
14?
14? So reply to it.
Yes.
Okay. So I think
My lord, may I just add that the new party that is added would need to be served, and the period for responding should be from the date of service.
yes.
Usually, I think.
Yes, yes.
Yes?
Yes. That's
Because it's a new
yeah.
party.
Exactly.
Yes.
Exactly. Thank you for that. Distinction there. I added 15 days from the date of service. All of you, 15 days from today. Agreed? I want to save on time, eh? Sure. So, and Lempaa, you ensure that you serve by the end of the day, eh?
Today.
Yes, today. So that you don't interfere with the.
At the end of today means evening.
Yeah. Service. And then the other respondents who have been served to file their respective responses within 14 days of today. So we are through with that issue. So we sign off, then we move to the next issues. So let's move on to the next issues while they sign that order.
Just for the sake of my lord and ladies, for the sake of those of us who are not in the legal profession,
Yes.
I just wanted to make it very clear that when you say that status quo, which was granted on 23rd of March,
Yes.
remains, that's what you are, remains standing until 18th of May 2026,
Yes.
right?
Yes, when we shall deliver the ruling.
So the status quo, which was
As at that time, we have clarified, we have added a simple sentence which is very important. So that that confusion of interpreting, diverging interpretation of the status quo goes. The status quo which was ordered is at 23rd of March 2026. The way things were then.
They remain that way.
That's what we are saying.
Yeah.
So for the sake of the lay people, that's what it means. So do not do any other interpretations. If there's going to be any intervention, we shall deal with it when it comes, okay? But for now, that's what we have settled. Now, let's move on now to the issues.
My lord, Professor Kalonzo is wearing a microphone. May I inquire why and who he is addressing? He's wearing a microphone on his lapel. I'm wondering, beyond the court, who else is being addressed through
Yes,
this
who else are
microphone?
you addressing? Because you didn't seek permission of the Lord.
My honor, my media here.
This is media.
You should have told them that you have your own media here.
Your honor, I would be obliged to any direction.
Yes, because now you are addressing it directly without the permission of the court. That's not reporting procedure. That's not reporting, isn't it? Proceed reporting comes up like they are doing now, and then they will go and report. You have allowed it, okay? But yours is live.
It is not going external, it is just a calling for sound to be clear, nothing going external.
No, we don't encourage that. We have a policy, a media policy.
Your honor,
We are open, as you can see, we are really open, isn't it? But do not do your own things, which may create some kind of discomfort among the participants. Comfort in proceedings is everything. You know that. It's part of the dignity and integrity.
Your honor, I also want to make you very comfortable that
Yes.
it is not being aired.
Switch it off in the meantime while you are still, even what we are talking now. You see now, the problem with that kind of approach?
Your honor, I'm obliged.
Yes, switch it off now.
Thank you.
So we are open to proceed. We are not, that kind of intervention is not acceptable. Judge, what do you think?
Yes, Prof. You see the concerns raised by council are valid. Please just switch it off.
Now the still see a mama, they very soft. Very I think now we agree. Anyway, that's okay, Ogola, next time, you see the commission, eh?
Thank you.
Yeah, so that we don't have unnecessary discomfort. So I think let's now move to the next issue. That is now gone. There was that issue by issue.
My lord,
You had applied your plan to be removed.
yes,
That
but
application is here.
my lord, there are two linked applications,
Yes,
which for the sake of pragmatism and time,
yes.
I would like my colleague, Mr. Ismail, to go first, mainly because he has a preliminary objection which covers half of the points I was going to make. It's a point of law.
Yes.
And then because there has been no response to his, I think, preliminary objection. And because he's the party that is not named in the amended petition, which you might find it easier to address his party, because the amended petition has not mentioned his client at all. So I think as you are dealing with allowing the amendment, you can deal with his client, then I will take up. It's
Yeah,
very
but-
similar points.
Okay, but I would like to know, we identified a problem initially,
Yes,
the mechanical outlay of the party.
yes, and that's,
Because there are three petitions
yes,
here.
yes.
Maybe he's in one of them.
He's in the second, my lord.
You see, that's where what I'm talking about.
Yes, he's in the second petition,
Yes,
but I think for the sake of good order, he will guide us going forward,
yes,
where we have only some of the petitions and not others, and we are not consistent in how we are describing people, because we can get into trouble being called the eighth respondent and we are not the eighth. So I was hoping, my lord, you could hear him. It's a very discrete point of law, and then it's something I also mentioned in my strikeout, but I can go after him. He only has 1 point, I have 2.
No problem, we'll deal with it, but we identified that as a problem.
It is an
Okay,
issue.
because I told you the way I do my consolidation. So it eliminates that kind of confusion. Because I still pick the three of them, then I list all the the petitioners in the brief, but giving them new numbers. Okay, and all the respondents, and then I give them from their henceforth, we refer to them as people. But that was not done here, hence this confusion.
This confusion.
But it doesn't mean that he is not named as a petition, as a respondent.
Yes, I think it's just clarity, because you see, my lord, if you are asking people to respond to an amended petition,
Yes,
for example,
yes.
and yet it is not clear because he's not, it's not clear that his client is part of that. That I was just saying it would be cleaner if we all understood what you mean.
Yeah, we shall resolve it. Before we leave
Yeah,
here,
yeah.
we shall resolve that question.
Okay.
For now, let's be here. Let's hear.
Thank you.
We'll give you-
I'm sorry, for good housekeeping,
Yes.
because we have filed an application which has been taken care of by the amendments, I thought it is wise that we get that off. Because now we are taken care of, and now, so that then we leave the floor in the podium to them to that extent, so that we don't have that pending.
So the ones for the.
Yeah, because the joinder now, so that you don't expend any more time in the joinder, because that has been taken care of by the amendment.
Oh, by the amendment.
Yes.
He withdrew the application.
Yeah.
That's what he means.
Yeah.
He withdrew the application.
Mr. Lempa's amendment has brought in the interested parties.
It has not.
Oh, really?
That's why I was like,
You would not have accepted.
Oh, I think the draft that I had
no,
received
it only added the.
was
one
different.
for Kenya Limited.
Was different.
Yes.
That's okay.
So yours is still outstanding.
Much obliged.
We'll get there. So let's see, remain your name, please.
Ismail Yoloche.
Ismail. So Ismail.
Yes, my lord.
Yes. Just 1 minute. Appeal should be as clear as nothing.
Yes, my lord, and the preliminary objection
Yes.
is dated the 4th of February 2026. My lord, and to clarify, that PO was filed in petition 836 of 2025. The petitioner there is one gentleman by the name Samuel Kara Masharia. And your lordship is disinterested in his petition. As you can see, he's not even. And none of the other petitions have cited my client. So that's the first point to make. And your lordship, I think that, as you rightly say, it is as clear as daylight. The preliminary objection on which my client anchors its case is that it is a foreign respondent. And under Order 21, Order 5, Rule 21 of the Civil Procedure Rules governing the service of pleadings on foreign defendants, your lordship, no leave was sought to serve this defendant or respondent outside the court jurisdiction. In other words, the court was not informed and no leave was sought as to why it is necessary to vex this foreigner with Kenyan court proceedings before service. So your ladyship, the way I had structured it,
Respondent number in
in 836, it would be respondent number 6. But you will not find it in what the amended petition which the court has now allowed to be on record. You will not find them there because the heading being maintained for that is the heading in 051. So that confusion we were talking about.
That's what I told you.
Vodafone Group PLC.
Yes, that's what I told you that the confusion arising out of that.
Yes, yes.
Does not mean that your plan is not.
No, I agree, Master, I agree.
And you only on that basis.
Yes, I agree.
Yes.
So to answer her ladyship's question, it is Vodafone Group PLC, that is my client.
That's your plan.
Yes. And your lordship and my ladies, we have put together written submissions dated the 22nd of March 2026. and those have not been responded to. And I will rest my case there. As I have said, that it is as clear as the PO suggests. Thank you.
My Lord, if briefly I can respond to my learned colleague said.
I thought we were arguing and then we'd sit and
Yeah,
respond.
they are
Intelligent.
because they are.
My Lord, so we have a strikeout application which is dated the 11th of February 2026. And we filed submissions in support. They are dated 26th of March 2026.
So the application is dated
The 11th of February.
February.
And submissions in support, so they are all in order. There are only 2 points. One was already covered by Mr. Ismail. The first point being that as a foreign entity located in South Africa called Vodacom Group, it is the 7th respondent currently in the amended petition. As a foreign entity, under our civil procedure rules, mandatory leave was required to effect service outside of jurisdiction, and that it is clear from the affidavits of service and the proof of service that no such leave was obtained. It was not applied for and it was not obtained. And I don't think, my lords, I should go over the arguments we've had on those, the mandatory nature. There are Court of Appeal authorities on that point. They are in the submissions, my lord. The second point was where I wanted to spend more of my time, which is who is the purchaser in this impugned transaction? Because I think, my lords, you've had various entities proposed to be relevant for the determination of these petitions. So our strikeout application was on the basis that the purchaser is Vodafone Kenya Limited. It is now the 8th respondent in the amended petition. And that this fact that it is the purchaser is not now in dispute in the amended petition. And I would refer you to certain paragraphs in the amended petition where they add Vodafone Kenya Limited. Paragraph 10, paragraph 12, where they say on the 3rd of December 2025, the 8th respondent, through a press release, announced its intentions to acquire 15% of the shares held by the first respondent on behalf of the Kenya people in the 6th respondent. It's paragraph 12 of the amended petition, and the public announcement that is referred to is annexed in the supporting affidavit of Mr. Tony Gachoka. It is TG1, exhibit TG1. So the point I'm making, my lords and ladies, is that the issue we made in our strikeout application as to who is the purchaser is now no longer in dispute. And in the circumstances we've raised before you, where there are rules in Kenya as to how you bring a foreign entity within the jurisdiction of the local court, and that those rules have not been followed, and where you are being told themselves by in the amended petition, who is the purchaser of these shares, we would say, my lords, that by allowing the amended petition, my point was, you have expressly accepted that the purchaser is not my client, nor is it Mr. Ismail's client, and the continued presence of us every time we come to court to listen to arguments on other matters is neither beneficial to the court, it is not a good use of judicial time and resources. You heard, my lord, we were very silent in the arguments on conservatory orders. My lord, that is because we are not parties to the transaction. So because we are not parties, how can we submit on an issue as to whether it should proceed or not? And on that basis, we would ask that you allow our strikeout application and you remove the name of Vodacom Group as the seventh respondent to these proceedings, and that you allow us costs, because, my lord, this information was in the public domain, even in the affidavit in support of the amended petition. It was in the public domain as early as 3rd of December 2025. And my lord, this petition before you was filed on the 26th of January, I believe. So the question we were asking ourselves with my client was, in light of that, why did they decide deliberately to bring in foreign entities to repeatedly misrepresent to this court that the shares are being sold to a non-Kenyan entity, when according to their own evidence, it's a Kenyan entity that is purchasing? And why, despite us filing and serving that application, why are we waiting until they amend the petition to extricate parties that should not be before you? It is not fair, my lord, and that's what we be concerned. Thank you.
Yes. Yes, my lord. Yes, on behalf of the petitioners, we responded to that particular application. Our submissions are dated the 14th day of April 2026, and the grounds of opposition are also grounds of opposition 14th day of April 2026. But besides that, my ladies, my lord, if you look at paragraph 22 of the amended petition, it is very clear that the seventh respondent is the eighth respondent holding company and also a shareholder of the sixth together with Vodacom International Holding. As such, the seventh respondent stands to benefit from the confusion, lack of integrity, and opaqueness of the sale of account on eighth respondent being the primary purchaser in the sale. So I do not know why a party wants to be condemned and harmed. It is very clear. I do not know why Ajawara actually wants his party to be condemned and harmed. It's very clear. And instead of taking a lot of time on that, we rely on our submissions as dated. We have provided case law.
So just repeat the date of your submission.
Yes, the submissions are dated the 14th day of April 2026, and they are grounds of opposition to that PO that is dated the same day, 14th April 2026, and it was served on Ajawara and Kana. And I don't know where the confusion is coming. We do know there is a lot of confusion. Vodafone, one is in South Africa, another one is in Netherlands, another one is in Kenya, but holds nothing. It is held by another one. All those are issues that will come very clear when we argue the petition. Thank you, my lords, my ladies. My lord, before in practice, we do know that once a party does not attend hearing, like the sixth respondent in 836, the party who attended hearing that day has the honors to serve that party, to prevent that party from being condemned and harmed in line with the rules of natural justice. So Mr. Ismail ought to have told us that indeed we have served today's hearing date and annex an affidavit, and that the respondent or the petitioner in petition 836 who has named me was served and is not in court. Then the court proceeds and give a notice to show cause why the petition should not be struck out. But you don't just stand here and say that they are not interested. Without, maybe they do not know, and they are laymen. Maybe they are not in the CTS as for us, who can probably forage in the CTS and find that there are submissions filed by a certain party. So, for the sake of rules of natural justice, let Mr. Ismail serve the party who has implicated him and who is not in court, for him to come and say that I have lost interest in this matter. But not for Mr. Anil to say without demonstrating that indeed he served. Thank you, my ladies, my lords.
Lordship and my ladies, I think Mr. Lempaa is extremely substantive provisions of law, the court should just continue hearing us. We will make a mockery of the Kenyan court system, Your Lordship, if we simply go around willy-nilly citing foreign defendants who have zero nexus to the pleadings and the substratum of the petition before the court. Thank you.
My lord, I think there seems to be, if there's confusion, my lord, I would suggest that the confusion has been to be here. Actually, we've been trying to be removed. When Mr. Lempaa says that Vodacom Group is a shareholder of the purchaser, Vodafone Kenya Limited, that is correct. And when he says that Vodacom Group is existing shareholder of Safaricom, that is correct. That is not in dispute. But we are a court of law. And as you know, in Kenya, we recognize the concept of separate legal entity. And it is the reason why Safaricom, with multiple shareholders, including the government of Kenya, including Vodacom, including even retail investors, cannot be considered the same as one individual shareholder. Safaricom is a separate legal entity, distinct from its directors, and it is clearly distinct from its shareholders. It is why Safaricom has its own senior counsel, and the Attorney General is represented by separate legal counsel, even though we all know that the government of Kenya is a large shareholder in Safaricom. You cannot say that a shareholder is the same as the entity it holds shares in. So I think that there's an election to be made, and it has already been made. They have brought finally belatedly the correct purchaser before you. But my lord, this information was there in December. Do you not think that it is strange that you're now being asked to add the correct purchaser after you have issued status quo orders, which in theory are now binding on a new party? It did not participate in the arguments. It was deliberately not included, and yet adverse orders are being made against the purchaser. And I say this to you, my lord, because you've heard repeatedly in representations today about a foreign, hostile takeover of Safaricom. But my lord and ladies, you are also being told at the same time in the amended petition that the purchaser is a Kenyan entity. Now, these two positions cannot be correct at the same time, can they?
Except of asking you a question.
Yes, my lord.
Where do you place beneficial ownership?
In the whole scheme of things, well, in company law, which is, we're dealing with limited companies, they are listed, they are not listed. So as a matter of company law, my lord, it is settled law in Kenya, as in many common law jurisdictions, that a company is separate from its directors and shareholders. Unlike myself, I'm an individual. It's very hard for me to say I'm a mother and then I'm an advocate and I'm all those things, I'm a wife, but I'm not a limited company. And you are being asked to issue very drastic orders, and you have been presented with a case before you, my lord, on a certain factual basis, but today you have allowed by consent a different factual basis. I'm just asking you, as lords and ladies, to ask yourself, why were you given this information, which was available in December? Why are you being given it today after you've extended the status for orders? Is it not surprising, my lord?
In your view,
Yes.
can a limited liability company be a beneficial owner in the context of Kenyan law?
It is a beneficial owner. It is allowed. Even in our registry, you can have beneficial ownership, my lord.
So we'll take note of this. We have recorded them.
Thank you, my lord. Thank you, my lord.
Thank you. So this one will also deliver our ruling on 18th.
Your Lordship and my ladies, I think I would just like to raise one issue. If you deliver your ruling on 18th of May, and you hold that we should still be here, and my clients decide we will not appeal and we will then submit to jurisdiction, because that's what you'll be telling us to do. Timelines for responding to this amended petition will likely have expired. So my lord, we are in a bit of a quandary because of that. You need to tell us that you will freeze time for us in the event your lordship and ladies decide.
So whatever directions we give, apply it that way.
But my lord, how do I submit to jurisdiction?
If we are going to remove you thereafter, that has not prevented us from removing you, okay? If we find that there is a reason to remove you, then we will remove you. And if there is anything to be cured by way of motion, just we also bring you post. But up to now, yes.
No, my lord, I understand that. But your lordship, you need to, I'm just asking the court a question. My preliminary objection is challenging the court's jurisdiction to entertain the petition as against my client. I cannot at the same time file a proper response to the amended petition because I consider it does not, I'm not supposed to be replying to it.
Do is there a protest? You said that there is issues there. You are still a party. That's my answer to you. But please don't be afraid.
It's not about being afraid, my
You are
lord.
still a party.
My lord, it's not about being afraid. It's about vexing a party that is not party to this litigation, is not supposed to be a party, with costs unnecessarily, my lord. Imagine replying to all this.
That is your application is fine. I'm telling you the protecting position is that you are a party.
And you see, my lord, now you have put me in the danger which I was not planning to get into when you said, let us agree by consent to the amended petition. I would not have agreed to that consent. Because, my lord, now I'm in that quagmire, which I was avoiding being placed in. Because now my lord is telling me, you reply.
File under protest, I told you there is a way of filing under protest, and then you say all those things, so that you are not submitting yourself, and you are making it very clear, please file objection. Okay? So file it under protest. So that will still be okay, it will cover you. So ruling is going to be on, yes, in respect of the appeal. Ishmael. Application dated. What's the date of the application, Ishmael?
The preliminary objection, my lord.
Oh, yours is a PO, eh?
Yes, it's a PO. It's the 4th of February, 2026. Your lord.
Mine was 11th of February 2026, strike out.
So that ruling with respect to those two applications, the fee on the application will be on 18th of May 2026, 2 p.m. Right, you're right doing that one. Says we go now to the great applications. There are two, one by Sonko, the other one by
Irungo Nyakera.
Gachoka.
Yes.
So there were lots of objections which were raised. We wanted to record the objections.
Yes.
So that now we can look at the objections in light of what they have submitted.
In relation to the Sonko application, we have actually filed on grounds of opposition. Very briefly, this party, under the guise of coming in as an interested party, is seeking to agitate and develop his own course of action and theory as to why the shares should not be sold. In accordance with the decision of the Supreme Court in Musyoka, there are very specific parameters upon which an application for joinder will be premised and considered. The Supreme Court has been very clear. Parties seeking to join must demonstrate what it will be saying that might propel the matter further, but cannot, by that application, seek to extend and develop matters outside the ambit of the petition itself. The grounds of opposition are clear, and my Lord, we will, once the court rises, provide the decision in the position of the Supreme Court. And the same applies to the other applications. The same applies. In fact, my Lord, in the new affidavit in support of the amended petition, the petitioners now refer to Nyakera as their expert witness. So if he is coming in as an expert witness, why should he join as an interested party? They refer to him as their financial expert. Yes, and they have annexed some reported report and his opinion on the valuation of the shares, valuation methodologies, and so on. And so there is no purpose to be served in his being included as an interested party. It would only delay the determination of the petition. Thank you.
Now the question is sit join her now. Although the provision of 771 of the two you can see the language used there is so broad-based as to render your discretion totally unfair. For two reasons. An interested party can make an oral application. By dint of that provision, you can see that there is, quote unquote, no material required to be filed before the court at that stage. And then you can see under sub-rule 2 of the 7, again, the discretion of the court remains wholly unaffected. Of its own motion, the court can join an interested party. Meaning that, from the perspective of the court itself, probably even drawing from its experience, institutional, the court can join an interested party. And therefore, to constrict, as you are being invited by London Council to then bar and close off this particular applicant who has opted, in deference to 7.1, to file a formal application, formalize his own application for joinder, would be contrary to the intent of the law. And I emphasize this, as seen against the broad-based provisions of Article 23 and Article 258 of the Constitution, where it says that anybody can actually even litigate on behalf of others, of a class, and such like. Now, as I close, you have not been told from that deposition point, what are the objections? Is this, I hope it's not my submissions, figured it out. Then you know that it's not an alarm, that something is amiss, or that we're about to have fire. We are safe. Thank you. As I close, you haven't been told, your lordship, that from their reading of that deposition, three things. A, that the applicant has a predisposition or comes across as a busybody or totally removed from the proceedings of trial. B, that he is averse, that he has specific issues about the M-Pesa, he himself as a subscriber. He is coming here as a voice. You have been told, well, like you saying in your own submissions, you heard about Boga, you heard about some other people. Now this is a real person, a flesh and blood person, coming to say that I am directly implicated. Lastly, you're being told that the applicant is, quote unquote, expanding the case before the court. Which petition? The three petitions? You cannot have a generalized attack on that court in order to bar someone with a legitimate, formalized application where he makes a deposition and delineates the specific grounds of the joint deposition, for which reason, my lord, my ladies, the applicant in front of the petition April 27 has not been shown in which way he would prejudice the respondent by the joint deposition. On the contrary, he has shown that he would enrich what is before the court for determination, and in fact laying material to demonstrate that this particular sale is outside the prescription of the law and is not to the benefit of a person who is a user of Safaricom's M-Pesa platform.
Yes, on behalf of yes, I'm actually, I wish to adopt the submissions of.
I'm sorry, my lord. There's an issue about the moratorium decision. I just wanted to say that that was based on judgment on a determined case. But in this instance, we haven't been thrown out.
We look at the deposition.
Thank you.
So start with the one where you say that being called as an expert witness.
Yeah, I wish to associate myself with the submissions of my learned senior, and I wish to inform the court that on the second day of February 2026, the interested party filed an application, and in that application, we did not annex his CV, but when you opened up the issue for further applications, we took advantage of that time to annex a CV of Mr. Irongo Nyakera. This is the person who actually advised the government on the IPO, and if he comes here, will be in a position to clarify whether that time the government was divesting the shares of floating an IPO. You know, we have presented.
Do you want him to come as a witness or as an interested party? You know, there are two issues here. Jody said that he doesn't have to come as a witness.
If they want to cross-examine Mr. Irongo Nyakera on the grounds of the expert document that he has filed here, we have no problem with them.
So you want him to come
Because
as a
answering the
witness?
question.
Yeah.
Answer my question. Do you want him to come as a witness, expert? Or
We-
you want him to come as an interested party?
We want to produce to have him as an interested party.
So that's your, let me record your view, eh?
Yes. He has annexed an expert report on the divestiture and why he believes it is undervalued, and therefore this court will benefit greatly from his input. You can read his expertise in his curriculum vitae. I don't know why the Attorney General does not want parties to bring all what they have for this matter to be canvassed and decided fully. As my learned colleague says, Murwa Teto had a judgment. In fact, I happen to have been in that matter. There was a judgment, and therefore the party that wanted to join was coming to support the judgment and not to start matters afresh. Saying that they cannot come here and take some side as an interested party. So that matter is distinguishable, Murwa Teto. It has no relevance in this matter. This party is coming as this matter is actually at its interlocutory stages. And any party coming to enrich the understanding of this case, my Lord, Muhammad Ali Badi and company is very, and versus the Attorney General is very clear on how to appraise expert evidence. And therefore, the Attorney General suffers no prejudice at all by parties who are probably dealing, as my colleague said, they are not many, and they have not been described as crank or busybodies or mischief makers. Kindly admit any party, because there is no prejudice that the government of Kenya would suffer by parties coming to tell them that we do not want you to proceed in the sale of Safaricom shares in the way you are doing. No prejudice whatsoever. So we humbly submit that you admit the parties, and we rest our case, my lords, my ladies.
I'm sorry to vex you, but those grounds of objection were never started. In fact, I was inquiring with my office. Did I miss something? They are not even listed to be served on, and yet they are opposed to my client's application. They are not served on me, not even listed on the to be served on, But nevertheless, I just needed to say that.
They'll sound.
No.
You probably missed them.
No. The
sound
parties to be served.
Yeah, sorry, but
We will sound them.
yeah, let's shorten the story.
Thank you. The parties to be served, my law firm is not your name.
Yeah.
Thank you.
Colleagues and I already have a basket full of things to attend to. Because we collect these rulings and judgments on a daily basis. This one became midstream. So we are going to make selfless sacrifices to be able to move this matter forward. But we have been convicted by our desire to serve, but we also give this one on 18th at 2 p.m. for the two applications.
That's right.
My Lord, there is directions on disqualification on the removal of the chairman of M-Pesa Foundation and the chairman of CBK. We still feel very uncomfortable when they sit here to defend matters where they have conflict of interest. So that one, kindly give us directions on that. We can argue it here. We have our submissions on record. We can as well argue and leave here at around 8, so that by 18th of May, Mr. Mukite and Mr. Ohaga will not be part of these proceedings, we believe.
You already know that? Lord, it is 5:25 p.m. It is very unfair to the bench to impose this workload. We've already had
My Lord,
one very substantial application and 2 or 3 other minor ones. My Lord, the question of representation can wait. In any event, we have already argued those other applications. It can wait. And Mr. Lempaa has not even responded. He was served today. Meanwhile, Mr. Professor has left. He has stopped broadcasting the proceedings, and he was one of the applicants. So,
sugar levels have gone down.
Yes.
What we will do on the 18th, once we deliver all these others, we can deal with the application there. Right?
Yes, well guided.
You comment or arguments, and then you can also deliver it in the meeting there.
In July.
Immediately thereafter, or the day after.
Yes, after the budget is read, my Lord, we are well guided. The ruling on their participation can be rendered after the budget has been presented. Thank you very much.
Let's deal with it on 18th. So we'll deal with those ones on 18th. We will agree by once again the problem with that.
He had it last time. Yeah. No, Vodafone.
Okay, now we can rise it.
Thank you very much, Liz. Thank you for your time. Thank you for your time. Have a good evening.
Have a good evening.
This one is for.
Gigi.